Welcome to the Explainer. Now, I know what you might be thinking. Tax law sounds like a snooze fest, right? Well, actually, scratch that. It is a high-stakes, highly structured game between the taxpayer and the taxman. If you operate a business, earn an income, or buy property in Singapore, you are already a player on this board. But how well do you actually know the rules? Today, we're mapping the entire life cycle of a tax dispute in Singapore, from the exact moment a tax law is born all the way to a fierce courtroom battle. Here is our roadmap for today. We'll be looking at where tax laws come from, the power of the taxman, fighting back in an appeal, questions of fact versus law, and finally, the power of precedent. Let's dive right in.
And just to make sure our playbook is spot on, we're drawing our insights today directly from the Tax Academy of Singapore's Advanced Tax Program. So this is the exact legal framework taught to the professionals navigating the system.
All right, Section 1, where tax laws come from. Think of this as Act 1, the rulebook. Before you even step onto the board or try to dispute a penalty, you absolutely need to know where the rules of taxation are actually born. It boils down to two foundational pillars. On the left, we've got statute law. Taxation is literally a creature of statute. Parliament writes these broad rules to reflect our societal norms. But, the real world is messy. Statutes just can't predict every single business deal. So on the right side, we have case law. The courts have to step in, interpret those statutes, and apply them to complex, messy human situations, creating precedents along the way. Now here's where it gets kind of wild. The rules aren't just local statutes debated in Parliament. Parliament actually hands over power to the Minister of Finance to create subsidiary legislation. And on top of that, you have international treaties like double taxation agreements or DTAs. These are hammered out by diplomats, not your everyday tax accountants. And get this, they can have multiple official language versions. Imagine trying to win a tax dispute where the defining text you're arguing over is actually the Spanish version of the treaty. Crazy, right? Moving right along to Section 2, the power of the taxman. Act 2. The referee.
So in the Singapore tax system, our referee is the Comptroller of Income Tax, or the CIT, and the game officially kicks off when the CIT makes an assessment. What does that mean? It means the formal process, or the final result, of figuring out exactly what you owe based on the act. It's definitely not a guess. It is the strict ascertainment of your liability, which the CIT hands to you in a notice of assessment widely known as an NOA. Now, you might be sitting there thinking the CIT holds all the cards, especially when the law literally says the CIT may do this or that. But take a look at this quote from the landmark JD case. The taxman's power is absolutely not absolute. There's no carte blanche authority here. Their administrative discretion has to be exercised fairly, reasonably, and in good faith. If a CIT decision outrageously defies logic, a court can and will strike it down. So how does this play out in everyday practice? Well, the CIT publishes these handy e-tax guides to help taxpayers out. But huge asterisk here. If you rely on a guide and things go sideways, the CIT has a disclaimer saying they are legally not responsible. On the flip side, simply ignoring an e-tax guide isn't actually a criminal offense, because it's just the CIT's view, not the hard statute itself. If you want 100% certainty, you pay for an advanced ruling. That's a move that actually legally binds the CIT to a specific position just for your arrangement.
Okay, Section 3, fighting back, the appeals. Act 3, the climax. What happens when that notice of assessment lands in your lap and you totally disagree with it? Well, a very strict clock starts ticking. This appeals process is intensely procedural. Companies generally have exactly 2 months, and other entities 30 days, to file a written notice of objection stating your precise grounds. If you miss that deadline, your fight might be over before it even begins, unless you can prove a reasonable cause, like a severe illness. If the CIT refuses to budge, you've got 30 days to lodge a notice of appeal, and then another 30 days for the actual petition of appeal.
Now, if you navigate that timeline perfectly, you don't just march straight into a public courtroom. You end up at the Board of Review. It's a specialized tribunal, usually a legally trained chairperson and a couple of experts like tax accountants, and crucially, proceedings are held in strict privacy. Because let's face it, your sensitive financial affairs shouldn't be public gossip just because you're having a dispute with the taxman. But here is the catch, and it's a massive one. The burden of proof, it falls entirely on you. You have to prove the taxman is wrong. Why? Well, as the courts pointed out in the CIT versus S&Co case, the taxman wasn't there when you made your money. The CIT has no way of knowing how your income was earned or your expenses incurred. You hold the receipts, so you carry the burden of proof. Let's pivot to Section 4,
questions of fact versus law. Act 4, making the distinction. We need to unravel what is arguably the single most important distinction in any legal dispute, which dictates how far your appeal can actually go. Ask yourself this: if a taxpayer flips 10 properties in a single year, does that constitute a business trade under the law? To figure that out, tribunals split the argument into two separate buckets. First, the question of fact. What actually happened in reality? Like, did his wife buy these properties on his behalf as nominee? That's a factual dispute about human actions. Second, you have the question of law. This is about interpreting the statute itself. Does the proven activity of flipping 10 properties legally meet the statutory definition of a trade? And this distinction is absolutely critical for your strategy. If the Board of Review rules against you on a question of fact, say they just don't believe your wife was acting as a nominee, you generally cannot appeal that to the High Court. The board is the ultimate finder of facts. You can only escalate your appeal to the High Court if you're arguing a question of law, claiming the board totally misunderstood the legal definition of a trade. Which brings us to our final section, the power of precedent. Act 5, binding rules. So how do the High Court's answers to those questions of law today become the rock-solid rules of tomorrow? It's all about consistency in the legal system. The critical Latin term you need to remember here is ratio decidendi, basically the reason for the decision. When a higher court makes a ruling, the ratio is the specific legal ground tied to the facts that actually decided the outcome. That core reason is what legally binds lower courts in the future. On the flip side, judges write really long judgments, and sometimes they just muse on other topics. Those are called obiter dicta, things said by the way. They are incidental comments that weren't crucial to deciding the specific case at hand. While they might be incredibly fascinating or persuasive, they are completely non-binding on future cases. Okay, so what if you're a taxpayer trapped facing an old, terrible precedent? How do you escape? You do what lawyers call distinguishing the case. You argue your current facts are materially different, or you point out that the old ruling was based on outdated social conditions from colonial times, or that a newly enacted statute overrides it entirely. Oh, and a quick warning, use foreign tax precedents with extreme caution. Tax is a highly specific, local statutory creature. Let's lock this concept of distinguishing down with an analogy. Imagine a past legal precedent where an inexperienced, reckless driver speeding in a Toyota Corolla hits a pedestrian and is found liable. Now imagine a new case. An experienced, careful driver in an electric BYD hits someone on a dark, stormy night. You have to extract the ratio of the first case. Was the precedent about the brand of the car, the Toyota? No way. It was about the reckless driving behavior. The careful BYD driver can attempt to distinguish their case because the material facts, their driving behavior and the weather conditions, are completely different. And there you have it, the complete architecture of a tax dispute in Singapore. It takes strict adherence to timelines, a crystal clear understanding of fact versus law, and the strategic knowledge of exactly when to fight. So looking at this board, with all its moving pieces and ticking clocks, the ultimate question isn't just whether you know the rules. It's whether you're ready to make your next move. Thanks for joining this explainer. I'll see you next time.